Let's look at a unique human rights tribunal case related to snow, disability, and discrimination. In an unusual twist on housing discrimination, a landlord was ordered to compensate a prospective tenant, not for denying them housing outright, but for including a snow removal clause that effectively excluded them due to their disability. The backstory: the landlord showed a rental unit in a multi-unit property to a potential tenant. During the viewing, the discussion turned to snow removal responsibilities, specifically that tenants were expected to clear snow from their designated spaces. The prospective tenant disclosed a back injury and mobility disability, stating they could not safely perform such duties. As a result, they claimed they were deterred from applying. No formal rental application was submitted to the landlord. No lease was signed. Yet the Human Rights Tribunal found grounds for discrimination. So what happened? Let's dive into how Tribunal member Mounsey evaluated this situation, and how the principle of equal access to housing played a decisive role in the outcome. We'll review a number of excerpts from the order Skokia v. Sokol, 2022, HRTO 1418, file number 2019-37495. See the link to the full order in the resources.
Analysis question. Was the snow removal requirement adopted in an honest and good faith belief that it was necessary to the fulfillment of its purpose? Excerpt. The respondent also has not demonstrated that the snow removal requirement was adopted in an honest and good faith belief that it was necessary to accomplish its purpose. As previously noted, no evidence was led to suggest that the snow removal requirement was implemented as part of a good faith belief that it was necessary to achieve its purpose of removing snow from in and around the building. Accordingly, this requirement has not been met. Analysis question. Is the snow removal requirement reasonably necessary to accomplish its purpose, or in the sense that the respondent cannot accommodate individuals sharing the characteristics of the applicant without experiencing undue hardship? Excerpt. The respondent also has not demonstrated that the snow removal requirement was reasonably necessary to accomplish its purpose. As previously noted, there has been no explanation for placing the snow removal requirement on tenants. Although the Sokols have explained that they implemented the snow removal requirement because Mr. Sokol is elderly and unable to shovel snow at the building, there was no evidence that requiring tenants to be responsible for snow removal was necessary for the purpose of maintaining the safety of the building and its surrounding premises. While the RTA prescribes that landlords are responsible for snow removal, it does not prevent a landlord from hiring a third-party contractor to perform such maintenance functions. At the merits hearing, Mr. Sokol indicated that he would have been prepared to allow the applicant to hire a third party to remove the snow. Based on the evidence before me, the respondent was not prevented from hiring a third-party contractor to fulfill these maintenance services, and no evidence was led which demonstrates that this obligation had to be placed on tenants at the building. Member Mounsey continued, writing in the order, I find that the respondent's snow removal requirement infringes Section 11 of the Code by placing responsibility for snow removal on tenants, and thereby adversely affecting individuals sharing the characteristics of the applicant as a person with a disability. I also find that the respondent has not provided a bona fide justification for this requirement, and has not demonstrated that the applicant could not be accommodated without undue hardship. At the merits hearing, Mr. Skokia testified about the impact of these events upon him. He indicated that he found these events to be devastating, and found that it slowed down his motivation and efforts to look for an apartment. He testified that it was difficult to find an apartment in Thunder Bay, Ontario, and that the apartments he saw were not as nice as the one available from the respondent. He also testified that he was not able to rent another apartment until August or September 2019, when he was able to find a one-bedroom apartment which did not have a second bedroom or laundry facilities. The member stated, in my view, $1,500 as compensation for injury to dignity, feelings and self-respect is an appropriate award in the circumstances of this case. The meeting between the parties was brief in duration, and the applicant was able to secure another apartment within a month or two of these events which met his original requirements. Order. The tribunal orders as follows. The respondent shall change the standard lease agreement for all of the buildings and apartments which he owns to remove any references to a tenant having responsibility for the removal of snow or ice from the respondent's buildings or apartments which do not comply with the Residential Tenancies Act, RSO 1990, C 17. The respondent may wish to refer to the standard form lease that has been issued by the Ministry of Municipal Affairs and Housing. The respondent shall provide the tribunal and the applicant with confirmation that such changes have been made to the respondent's standard lease agreement within 90 days from the date of this decision. The respondent is not required to make such changes for lease agreements with tenants which were entered into before the date of this decision. The respondent shall not advise prospective tenants that they are responsible for snow removal or maintenance of exterior common areas at the respondent's buildings or apartments, unless such advice or requirements comply with the Residential Tenancies Act. And the respondent shall pay the applicant $1,500 in compensation for injury to dignity, feelings, and self-respect within 30 days from the date of this decision. End excerpts.
We can see from this example the importance of dealing with prospective tenants from advertising to the initial point of contact and through the rental process before a tenancy is established, to ensure that human rights protected grounds are not inadvertently breached. It's a great lesson for any landlord wishing to improve their rental housing business.